What we are going to do, we have 2 lawsuits pending in the Middle District Federal Court in Greensboro and with ACLU of North Carolina, along with ACLU National, and the 9 families that we represent. What we're going to do is move to dissolve the stays that had been put in place in those cases, so those cases can move forward expeditiously. You heard Attorney General Cooper earlier this week say that he would not stand in the way of those cases proceeding. And then we're going to seek at least a partial judgment in those cases based on the Bostick decision. It's not a complicated legal argument. Here's the Fourth Circuit, which controls district courts here in North Carolina, invalidating a legally indistinguishable marriage ban in Virginia. The same thing has to happen here in North Carolina. I think so at the bottom of your question is, when do we see practical effects from those sorts of decisions? So the Virginia decision has been will not take effect for at least 21 days. I think everyone expects that it will be appealed up to the Supreme Court. It's possible that a stay would be entered. It's possible that the United States Supreme Court will choose not to hear this. And I think if that's the case, you could have marriages start to occur in Virginia, potentially in North Carolina, early in 2015. You could have the Supreme Court hear this case in its 2014-2015 term, which would probably be a spring 2015 decision, and marriages could occur shortly thereafter. It's possible the Supreme Court could hold this over to its 2015-2016 term, which would delay things by another year. But I think that as you go through that sort of 1, 2, 3 list of alternatives, at the bottom, what we're saying is it's now a matter of when, not if. Marriages are going to occur in North Carolina, and Amendment 1 is going to come off the books.